During my consultations, one of my most common questions, usually asked by the party who does not intend to be the parent of primary residence of the children, is should I stay in the marital residence now, or should I leave during this period when we're trying to get divorced? Now, again, every question is fact specific. In this particular question, we'll have the hypothetical that both parties want to be the physical custodian of the children. If that were the case, I don't believe your client or my client I would ever advise them to leave the home and go live somewhere else while the wife or the husband, whoever was staying in the home. In this hypothetical, I'm going to amend the hypothetical and say that I represent the husband and he wants to have 50-50 custody, physical custody with the wife. And the wife wants him to leave the home because they're fighting, and he thinks that maybe they should leave the home because they're fighting. However, once he leaves that home, he loses control over how often he sees his children and what the party left in the home, how they will react with the children. So on its face, my first response would be do not leave the home. On the only circumstance in which I would advise my client to leave the home is if the parties arrived at a temporary visitation schedule where it was 50-50, and my client got to see the children 50-50 at his new place, and the wife had the children at the marital residence 50-50 in her place, and that would sort of keep it status quo. The children are still being in a new place, and they're still at their home with their mom, so we're not disrupting everything for them. They're still going to the same school system, things of that nature. If that were the situation, under those circumstances, I would advise my client it's okay to leave the home. Not something I would want him to do, but if he wanted to, for whatever their reasons were, it would have to have a visitation schedule or parenting time schedule written down and signed by all and a judge, and then I would say, okay. Another fact that changes the hypothetical is, do the parties have enough money to pay for the marital residence and have another apartment or another home where the other parent resides? In addition to having the children issue of who's going to have the kids for how long in this temporary setup. If the parties have enough money to split up, and if the parties arrive at a written agreement where each party knows what they're going to be doing with the children, then I would tell my client if they want to leave the house, it's okay. I wouldn't advise them to do it unless there was enough money and a written parenting time schedule signed by a judge was in place. If those two issues were in fact in order, then I would say to my client, if you want to leave the home, you can. But under other circumstances, I would advise my client not to leave the home and to stay in the home until the divorce is over. Many times this is really driven by finances. In many cases, there's not enough money to pay a $3,000 mortgage in a $2,500 apartment because you have to house 2 or 3 children in that apartment, so you need at least 2 bedrooms, most likely 3. So in summary, I would say that the general proposition would be to stay in the home until the divorce is over. And I've given you the 2 real scenarios where if you can get them under control and come to an agreement with them, then it would be okay to leave the home during the divorce, during the pendente lite phase of the divorce. Complaint for divorce till the end of the case. That's called the pendente lite phase. You'll hear that name a lot, that Latin word, and you need to know what it is because your attorney is going to say it as if you know what it is.